So, good morning, everybody. Ladies and gentlemen, it is a pleasure for me to be here today and to be able to share with you, on behalf of the Energy Community Secretariat, one of our latest initiatives, an initiative that we believe it's going to make a change in the energy market and in the dispute resolution world as well. The title of this talk is New Formats of Dispute Resolution within the Energy Community. But before going to the new formats of dispute resolution, I'm going to speak a bit about energy community itself and about the current ways of dispute settlement we have. Is this too fast for the translators? Or it's a bit, okay. The Energy Community, as I'm sure you know, is an international organization dealing with energy policy. The treaty establishing the Energy Community was signed in 2005 and entered into force in 2006. The treaty brings together, on the one hand, the European Union, and on the other hand, its neighboring countries, so far the countries from Southeast Europe and the Black Sea region. The main purpose of the Energy Community is to create an integrated pan-European energy market on the basis of a legally binding framework. This further will translate into enhanced security of supply, an improvement in the environmental situation, and enhanced competition in the region. All these three elements, furthermore, are going to act together for the ultimate benefit of the consumers, which means that the consumers should get the best value for the money. Of course, the development of this pan-European market would, however, be impossible without substantial investment. And by substantial investment, I mean investment in power generation and in networks. So, a part of our daily work at the Energy Community Secretariat is making the Southeastern Europe, the Black Sea region, an attractive investment place for investors. However, we all know that legal obligations are nothing without enforcement, and we all know that very complex business relations, as the ones in the energy sector, will inevitably lead to disputes. So, in time, whether we liked it or not, we became involved in the enforcement of the legal obligations and into the settlement of the disputes that arose in the market. From the very beginning, the Energy Community had a dispute settlement system. In the beginning, this dispute settlement system has been addressing only breaches by the contracting parties of the Energy Community law. The dispute settlement procedure is described in a consolidated set of rules which have recently been amended and revised by the Ministerial Council. To make this very simple, the dispute settlement procedure in the Energy Community resembles the infringement procedure of the European Commission, with the only difference that at the end there is no judicial decision. Usually we commence such a dispute settlement procedure as following a complaint, but there are also cases in which we do this ex officio. For example, while reviewing legislation, we realize that the legislation is not compatible with the Energy Community law. The dispute settlement procedure provides for a so-called preliminary procedure. It's a three-step procedure which commences by an opening letter, a reasoned opinion, and a reasoned request. All these documents are drafted by the Secretariat. The final one, the reasoned request, is the request to the Ministerial Council to issue a decision of non-compliance. What is very important to say is that throughout this procedure, the contracting party concerned has the opportunity to be heard. It has the opportunity to explain its conduct. It has the opportunity to, by its own will, correct the breaches of Energy Community law. In our experience, this procedure, this pseudo-infringement procedure, has been a very effective tool in enforcing Energy Community law on the contracting parties. However, what must be said is that this procedure is very restricted in scope. It does not address private disputes, and it does not address disputes between, for example, an investor and the state authorities when such disputes is not based on a breach of Energy Community law. Of course, for commercial disputes, for investor-state disputes, there are already tools available for the investors and the companies. For example, just to mention the most important ones, for investor-state disputes, the most widely known are, of course, investor-state arbitration, as is the one under the Energy Charter Treaty or the ICSID Convention. Of course, investors which are more concerned about confidentiality can go for ad hoc investment arbitration. All these options, this menu of possibilities, is usually found in bilateral investment treaties concluded between countries. Of course, commercial arbitration, where the ICC is so far the leading institution, at least in Europe, is an option for purely private disputes. And of course, there are always the state courts. If you don't go to arbitration, then you go to litigation in state courts. Of course, that arbitration is an option which cannot be neglected, and an option which has led to happy resolution of many disputes so far. But it does have a few shortcomings, and I'm going to mention them shortly. To begin with, if you just look at the ICSID website, you will see that investor-state arbitration proceedings are very lengthy. Their length translates into costs, and these costs are millions of dollars for both the investors and for the responding states. This leads to another big disadvantage. Because of the costs, it is only a select big of companies, the very big companies, which can afford to sue a state in investor-state arbitration. Small and medium enterprises, for example, will never be able to pay 10 million euros, which is the average cost of an investor arbitration, will never be able to pay this amount to sue a state which breached their right. And maybe the most important disadvantage of investor arbitration in the energy sector is the fact that once the request for arbitration is filed, usually the business relation is terminated as a result of the initiation of arbitration proceedings. In most fields, maybe this would not necessarily be a problem, but in the case of energy, which is such a politically sensitive field, in which we still do have a lot of de facto monopolies, the termination of the business relationship can have very serious consequences in the end for the consumers. Throughout the years, the Energy Community Secretariat has been involved in many disputes which arose in the energy sector, in the contracting parties. And with time, we were not just taking note of them, but we became actively involved in their settlement. We do believe that the fact that it is a neutral international institution gave trust into our work, both for the investors and for the contracting parties. We mediated a series of disputes. The most important ones was the dispute between ČEZ in Albania, EVN in Macedonia, the very recent case of Gas Natural Fenosa in Moldova. All these cases could have escalated into very long and costly investor-state arbitrations, but we managed to mediate them in just a few months and with no costs. And now the business relation is continuing. So, building upon the experience of this successfully settled disputes, in October 2016, which is just a month ago, we established a dispute resolution and negotiation center, which is attached to the legal unit of this Energy Community Secretariat. We want this, and we see this as an alternative to arbitration and litigation, an alternative that offers remedies in cases arbitration and litigation cannot work or cannot work so well. It is developing as we speak, but for the time being, our activity is channeled on three main pillars. The first one is mediation of investor-state disputes, like the ones I've been talking a bit earlier. Then the second one, the second pillar, is offering negotiation support to national authorities in their negotiations with the private parties. From our experience in the region, we noticed that national authorities of the contracting states many times do not have the know-how and the capacity to have negotiations with very big and skilled companies. That is why, at the beginning, just this year, we organized negotiation trainings, and we are in the process of establishing negotiation network. And finally, the third pillar is within the dispute settlement procedure that we already have against the contracting parties, we want to give the contracting parties the opportunity to go to mediation, to select a mediator, an external mediator, from a panel of mediators to settle the dispute faster and more efficiently. The recent successfully settled dispute between Gaz Natural Fenosa and Moldova, and the very positive feedback that we received both from the investor and from the national authorities gave us the confidence that in the energy sector, at least, mediation as opposed to arbitration and litigation is a very efficient way of solving disputes, and for a number of reasons. First of all, the services of this dispute resolution and negotiation center are free of charge. It is the experienced staff of the secretariat that will act as mediators, and they will charge nothing for their services. Then, in the secretariat, we are able to draw upon the experience of our colleagues, and I mean engineers and economists, to be able to deal with these very complex problems that are put before us, and this is an advantage compared to any law firm. Then we will establish a panel of mediators for the cases in which the parties will not want to have us as mediators, but will want to have external mediators. And we are trying to figure out how to do it to keep the fees to a minimum. And you will be informed and you will be invited to apply for this panel of mediators. And very importantly, in our experience, it was very useful that during mediation, we had the flexibility that arbitration and litigation do not have. Of course, there is always concern for the rule of law. There is always concern for the legal obligations under the energy community law. But when we don't have a strict time frame and when everything is flexible, then the parties are more inclined to reach a compromise. And what I think is the main advantage of the center is the fact that unlike a court, unlike an arbitral tribunal, during these disputes, we are not so much concerned about who's wrong and who's right. It's not a judgment that we make at the end. We just try to support the parties to reach a compromise and a middle way that's best for them and for the business relationship and for the continuance of the business relationship and the stability of the energy market. Well, last but not least, of course, we think we're extremely well placed in the heart of Europe, very well, easy reachable from all the contracting parties and from the European member states. And well, we look forward to work with you, either to solve your disputes, which you may have in the future, or to work with you as experts or mediators. Thank you very much.